Hello guys, welcome back to the channel, and please don't forget to subscribe if you're new to the channel. In this continuation, we are going to give you a complete guideline about marriage green card. Let's get into the video. US citizens and lawful permanent residents can apply for marriage green card to help their spouses gain permanent residence in the United States. A marriage green card allows the spouse of a US citizen or green card holder to live and work anywhere in the United States. A green card holder will have permanent resident status until they decide if they wish to apply for US citizenship, for which they become eligible after 3 years. The first step in the process of getting a green card through marriage is to submit Form I-130, US Citizenship and Immigration Services, which is part of the US Department of Homeland Security. The spouse that is a US citizen or a green card holder is known as the petitioner on Form I-130, and the spouse applying for a green card is known as the beneficiary. The petitioner will need the following information in order to properly complete the Form I-130. 1. Address history for the previous 5 years. 2. The name of any former spouses. 3. The date any previous marriage ended. 4. All jobs worked in the previous 5 years. 5. Any previous immigration petition filed in support of foreign beneficiary. The beneficiary will need the following information in order to properly complete the Form I-130. 1. Address history of the previous 5 years. 2. The name of any former spouses. 3. The date any previous marriage ended. 4. All jobs worked in the previous 5 years. 5. If present in the United States, a Form I-94. 6. Any previous immigration proceedings. In order to complete the Form I-130, the following documents are required. 1. Petitioner must provide proof that he or she is a United States citizen or legal permanent resident. Documents that satisfy this requirement include a birth certificate for US citizens or a green card for permanent residents. 2. Proof of marriage. The most common document is a marriage certificate. 3. It is also important to provide proof of marriage termination if any spouse has had previous marriage. A divorce document indicating the name of the petitioner or beneficiary, as well as an indication that the divorce is legally valid where granted, is a common example. 4. 2 passport-sized photos of both the petitioner and the beneficiary are required. In addition, proof of a bona fide in marriage is also required. Proof can include joint checking account statement, birth certificate of child born in the marriage, evidence of joint financial responsibilities like a mortgage or utility bills. The couple need to provide evidence that shows the spouses are married and are not trying to trick the immigration service in order to obtain a green card. The filing fee for filing Form I-130 is $535 and should be sent while filing the petition. What happens after submitting Form I-130? After submitting Form I-130, the United States Citizenship and Immigration Services USCIS will review the application for completeness and will let you know if something is missing. That is why it is important to make sure you have provided all the documents necessary to complete your application in an effort to avoid a delay in processing. After checking the form for completeness and making sure all the documentation is provided, USCIS will review Form I-130. For example, the USCIS will review the marriage certificate provided with the Form I-130 in order to make sure that the marriage is a legal marriage and the place the ceremony took place. Other documents will also be reviewed, such as any proof submitted in support of a bona fide marriage, and examine the petitioner and beneficiary's passport. When the USCIS approves the I-130 petition, it will notify the petitioner and then send the immigration file to an appropriate place. Where this place is will depend on where the beneficiary is. If the beneficiary is in the United States, then the next step will be to file the adjustment of status. If the beneficiary is outside the US, it will be sent to the appropriate overseas U.S. consulate or embassy. Let's know what the adjustment of status is. Adjustment of status is the process where an immigrant changes his or her immigration status from a non-immigrant to a permanent resident. If an immigrant is not eligible for an adjustment of status, then he or she must use consular processing. In order to be eligible for adjustment of status, the following must be true. 1. Immigrant is physically present in the United States and will remain physically present throughout the adjustment of status process. 2. Immigrant entered the country legally. This means the immigrant entered the country with required documentation and was approved entry by the USCIS, and immigrant has an approved form I-130. If the immigrant meets these three eligibility requirements, then he or she will need to complete a form I-485, the application to register permanent resident or adjustment status. The following documents are needed when filing form I-485 application. These includes are necessary to show that the beneficiary is eligible for a green card. 1. Proof of lawful entry to the United States, such as I-94 records. 2. A copy of the applicant's birth certificate and passport. 3. Proof that the Form I-130 petition can financially support the beneficiary. 4. The beneficiary must take a medical examination by a USCIS approved doctor. 5. If the applicant has ever been arrested, he or she must provide proof that there was no conviction. Spouses of U.S. citizens applying for a marriage-based green card and living in the U.S. can file Form I-485 at the same time as petitioner files for Form I-130. The form can also be submitted after the Form I-130 has been approved. The filing fee for the Form I-485 is $1,225. The processing time for the Form 485 when submitted by a spouse of the U.S. citizen is 9 to 12 months. The processing time for the Form 485 when submitted by spouses of lawful permanent resident will take longer due to having to wait for green card availability. This generally adds an additional 8 to 10 months to the processing time. It is also important to remember that the beneficiary must maintain an immigrant lawful status while the Form I-130 and Form I-485 are being processed. Processing of green card when applicants living abroad. Aside from an adjustment of status, another avenue to receiving a green card is through consular processing. Consular processing is the only method available to people who are currently not physically present in the United States. After the Form I-130 is approved, that the National Service Visa Center will notify the petitioner that visa is about to become available. Once a visa is about to become available, the green card beneficiary can begin the process of obtaining a green card through consular processing. The following is the documentation required for consular processing. The applicant must submit the application for immigrant visa and alien registration. This is Form DS-260. The fee for this application is $325. The petitioner will submit an affidavit of support Form I-864. The affidavit of support tells the USCIS that the petitioner will financially support the beneficiary if the beneficiary is unable to support himself or herself. The affidavit of support costs $120 to file. Interview with the U.S. Embassy or Consulate. If the beneficiary is abroad, then the interview will take place in a U.S. Embassy or Consulate. When a visa becomes available and the Form DS-260 has been received, along with all other documentation, then the consular office will schedule an interview with the applicant. The consular interview is a very important part of the process. You should expect a lot of questions about your spouse and your relationship with your spouse. If the consular approves the immigrant visa, then the applicant will be given a visa packet. These visa packets will allow the applicant the opportunity to be admitted to the United States. When the applicant goes to the United States, he or she will give the visa packets to the custom officials at the entry port. If customs finds the applicant admissible, then applicants will be admitted as a permanent resident. USCIS will mail a green card to the newly admitted permanent resident within 45 days. What happens next depends on the length of the marriage at the time of the green card approval. Have you been married for less than 2 years? The spouse will receive a CR1 conditional green card. Conditional green cards are valid for only 2 years. Couples together must file Form I-751 during the 90-day immediately before the expiration of the conditional green card in order to remove the condition and obtain a permanent green card. Upon receiving this form, USCIS will re-evaluate the couple's marriage to make sure it is authentic and that the couple did not marry only for immigration purposes. Have you been married for more than 2 years? The spouse will receive an IR1 green card, a permanent green card that is valid for 10 years. In most cases, renewing this 10 years green card is a simple process and does not require the couple to prove the authenticity of their marriage again. Thanks for watching, and please don't forget to share the video and don't forget to subscribe to the channel for more updates. Bye.